In London on the 11th of December 2015, Jermaine Baker was shot dead by a Metropolitan Police officer known only as W80 in Wood Green. Mr. Baker, who was unarmed, was shot during a police operation to prevent a suspected plot to free two prisoners being transported to Wood Green Crown Court. Mr. Baker's death led to an investigation by the Independent Police Complaints Commission, which was continued by its successor body, the Independent Office for Police Conduct, and a criminal investigation which did not result in criminal charges being brought against the officer who shot Mr. Baker. A public inquiry into Mr. Baker's death launched in June 2021 and reported in July 2022, finding that the police operation in which Mr. Baker was killed had involved a series of failings, but that Baker's killing was nonetheless lawful. In September 2023, the IOPC announced that Officer W80 would face gross misconduct proceedings in relation to the shooting. The majority of British police officers do not carry firearms. A minority of officers belong to specialist armed teams, the Specialist Firearms Command in London, and are trained to use weapons. Firearms duties are voluntary. Officers who discharge their weapons must be able to justify their actions as reasonable force, used in self-defense or the defense of another. The decision to fire rests with the individual officer, who remains legally accountable for his actions. Police shootings are investigated by an oversight body, the Independent Police Complaints Commission, IPCC, in 2015, which was succeeded by the Independent Office for Police Conduct, IOPC, in 2018. In 2011, riots broke out after Mark Duggan was shot dead by police in nearby Tottenham. Jermaine Baker was 28 years old. On the 11th of December 2015, he was sitting in the front seat of a car near Wood Green Crown Court in North London. He was part of a group that planned to free two prisoners due to arrive at the court in a prison van for a sentencing hearing in relation to firearms offences. The Metropolitan Police were aware of the plan and had intelligence that the gang had access to firearms and thus deployed armed officers to prevent the escape. When the police surrounded the vehicle at around 9 a.m, one officer, identified only by his call sign W80, opened fire. The single shot passed through Baker's wrist and neck. An air ambulance was called, but Baker was pronounced dead at around 10:30. A replica Uzi submachine gun was found in the car, but Baker was unarmed when he was shot. In the days following the shooting, several media reports claimed that Mr. Baker was a gang member and linked him to Mr. Duggan, who was shot by police 4 years earlier. The Met stated on 18 December 2015 that Baker was not listed in their database of known gang members. The IPCC investigation discovered that the police had placed a covert listening device in the vehicle, in Mr. Baker's vehicle, which recorded the occupants saying they were not in possession of a real weapon. This information was not communicated to the armed officers who were to make the arrest. The officers were briefed that the occupants of the vehicle were armed and intended to use firearms to commit crime. On the 14th of December, the Monday after the shooting, the Met suspended W80 at the request of the IPCC, who announced that they were investigating the incident as a homicide. The officer was arrested on 17th December and interviewed under caution. The Police Federation rejected the IPCC's characterization of Mr. Baker's death as a homicide and said the life of the arrested officer had been thrown into disarray. Sir Bernard Hogan Howe, the Commissioner of the Metropolitan Police at the time, said the IPCC's decision to launch a homicide investigation was unusual and that he did not know the basis for the characterization. In November 2016, the IPCC referred the case to the Crown Prosecution Service, CPS, for a decision on whether to, indicating that it believed the investigation showed that a criminal offence may have been committed. In June 2017, the CPS concluded that the officer would not be charged on the grounds that there was no realistic prospect of a conviction. W80 stated that he had acted in self-defense and had believed that Baker was reaching for a firearm. The CPS believed that a prosecution could not prove to the required standard that W80 was being untruthful about his belief that Mr. Baker was armed and reaching for a weapon. Mr. Baker's mother requested the CPS reconsider its decision under the Victims' Right to Review scheme, and the local Member of Parliament, David Lammy, wrote to the Attorney General to request a review of the CPS's decision. In March 2018, the CPS reconfirmed its decision not to bring charges. The IPCC forwarded its report to the Met to consider whether W80 should face disciplinary action. The IPCC and the Met held a public meeting on the 17th of December 2015, 6 days after the shooting, in response to community concerns similar to those which arose after Mr. Duggan's shooting in 2011. The meeting was chaired by community leaders. Cindy Butts represented the IPCC as the commissioner overseeing the investigation, and Chief Superintendent Victor Olesa, the borough commander, represented the Met. 4 men were arrested as part of the operation and charged with conspiracy to aid the escape of 2 prisoners. 2 were also charged with possession of an imitation firearm. The 2 men they were trying to free were sentenced to 14 years in prison. Shortly after the shooting, the officer went missing and attempted suicide. Following the officer's arrest, the Police Federation of England and Wales warned that if the officer was charged, other armed officers could refuse to carry firearms in solidarity with W80, or out of concern that the law did not sufficiently protect them. The officer in command of the firearms operation, known as the Tactical Firearms Commander, and identified by his call sign FE16, in which Mr. Baker was killed, retired from the Met in 2016. At the time of his retirement, the IPCC was considering bringing disciplinary action against him for gross misconduct in relation to the briefing he delivered to his officers before Mr. Baker's shooting. Mr. Baker's family brought a judicial review of the Met's decision to allow the officer to retire, as retirement would put him beyond reach of disciplinary proceedings. The IPCC initially indicated it would support the proceedings to prevent the officer retiring, but later withdrew its support because it believed the allegations against the officer would meet the threshold for misconduct, but would not constitute gross misconduct, and so could not lead to the officer's dismissal. The High Court dismissed the claim in October 2016 on the grounds that the officer's right to conduct his life as he wishes outweighed the potential benefit to Mr. Baker's family of him remaining in post. Following the verdict, Mr. Baker's family and the charity inquest accused the IPCC of betraying them and of failing to hold the Met to account. The family's solicitors argued that the IPCC's statement was misleading and that the evidence indicated gross misconduct had occurred. In 2019, the IOPC, having inherited the investigation from the IPCC, directed the Met to bring disciplinary proceedings against W80 for misconduct. The IOPC believed there was a case for W80 to answer that he had used excessive force. W80 and the Met sought a judicial review of the IOPC's direction on the grounds that the IOPC had applied the law incorrectly. They argued that W80 was justified in his use of force as long as his belief that his life was in danger from Mr. Baker reaching for a weapon was honestly held. The IOPC argued that the belief must be both honest and reasonable. The High Court sided with W80 and quashed the IOPC's direction. The IOPC took the issue to the Court of Appeal. The IOPC continued to argue that police officers should be sanctioned for use of force in cases where their belief that force is required is unreasonable or irrational. Mr. Baker's family's solicitors argued that a finding in favour of the police, who argued that officers should not be sanctioned for use of force in such cases, would weaken police accountability. In October 2020, the Court of Appeal reversed the High Court judgment and ruled that disciplinary proceedings could commence. The ruling confirmed that in cases where officers claim to have made an honest mistake in concluding that they faced imminent danger, their use of force may nonetheless constitute misconduct if that belief is found to have been unreasonable. In response to the ruling, which reopened the possibility of disciplinary proceedings against the officer said he would apply for leave to appeal. The Supreme Court dismissed the appeal in July 2023. In September 2023, the IOPC confirmed its decision that W80 must face disciplinary proceedings. An inquest into Mr. Baker's death was opened on the 22nd of December 2015 and adjourned pending the outcome of the IPCC's investigation. In February 2020, Home Secretary Priti Patel announced a public inquiry into Baker's death in place of an inquest. Mr. Baker's family criticised the 4-year delay in announcing the inquiry and called for the process to focus on the reasons why Mr. Baker was killed, the planning of the operation, and the level of force used by the officer. A pre-inquiry hearing in the spring of 2021 heard that the officer who shot Mr. Baker had been appointed a firearms instructor with the SCO 19 Firearms Unit. Baker's family's solicitors described the appointment as surprising and troubling. The inquiry opened in June of 2021. On its first day, the inquiry was told about the police's covert recording, which indicated that there was not a weapon in the vehicle in which Mr. Baker was killed, the officer's disappearance and suicide attempt, and the failure of 2 police teams involved in the operation to communicate with one another. Nearly 25,000 pages of written evidence were disclosed to the inquiry. In July 2022, the inquiry found that the police operation in which Mr. Baker was killed had involved a series of failings, but that Mr. Baker's killing was nonetheless lawful. The inquiry found that the officer who shot Mr. Baker was not motivated by a commitment to public safety. Instead, the findings concluded the police operation was motivated by a delusional belief that they were acting to eradicate lethal firearms from North London. The inquiry chair, Clement Goldstone, said he had found no evidence that race played a role in Mr. Baker's death. The Met police officer who shot dead an unarmed man in North London must face gross misconduct proceedings, the police watchdog has said. Jermaine Baker, who was 28, was killed during a foiled attempt to free an inmate from a prison van near Wood Green, Crown Court in December 2015. A replica firearm was found inside the car in which Mr. Baker was killed. The Met said it would review the Independent Office for Police Conduct IOPC decision. The police watchdog previously won a Supreme Court challenge over a past decision to bring forward a hearing. In 2016, the Crown Prosecution Service decided the officer, known only as W80, should not face criminal charges. However, the IOPC told the Met gross misconduct proceedings should be brought against him. W80 challenged that direction in the courts, and in July, after the issue had been considered at 3 levels of the legal system, the Supreme Court ruled against him. Prior to this, a public inquiry determined that Mr. Baker was lawfully killed. IOPC Acting Director General Tom Whiting said, "This case has been through protracted legal proceedings which have been extremely challenging for everyone involved, not least W80 himself and Jermaine's family. We have now upheld our original decision that W80 should face a gross misconduct hearing. This isn't a decision we have taken lightly, but we believe that it was the right decision in 2015 and remains so following the clear ruling from the Supreme Court in July." Deputy Met Commissioner Lynn Owens said the force would review the IOPC's decision and reasons and consider its next steps. Normally, the force would oversee a disciplinary hearing with a legally qualified chair. However, the IOPC said it would ask the Met to consider bringing in another police force because of recent commentary about this case. Ms. Owens questioned this request, saying, "We do not accept that our wider call for support and legal reassurance for armed officers impinges upon our independence, nor the impartiality of the misconduct hearing process." She said the force would seek legal advice on the issue. Jermaine Baker's mother, Margaret Smith, welcomed the IOPC's decision to bring gross misconduct proceedings against W80. Ms. Smith also said the family would strongly support the IOPC's call for another police force to lead the hearing. In a letter to the Home Secretary at the weekend, Met Police Commissioner Sir Mark Rowley raised the case of W80 in the context of his concerns about the treatment of officers who fire their weapons. Sir Mark said even if officers stuck to their training, they faced years of protracted legal proceedings which impact on their personal well-being and that of their family. After the CPS decision not to prosecute W80, Sir Mark Rowley said the officers' credibility remained intact and was supported by policing and reconstruction experts. Ms. Smith said the Commissioner's statements amounted to an apparent capitulation to firearms officers' demands for impunity. The Police Federation of England and Wales, PFEW, has called on the government and policing leaders to determine a time limit for disciplinary proceedings against officers. National Chairman Steve Hartshorn said, "How is it right to allow endless, repeated and ongoing investigations into officers' actions at an incident without any time limit at all? The negative impact of this prolonged uncertainty on an individual, their families and their colleagues cannot be ignored or underestimated, nor can the impact it has on others involved. PFEW has been calling to determine a time limit for disciplinary proceedings against officers and is campaigning for it to be set at 12 months from the day allegations are made." Margaret Smith, mother of Jermaine Baker, makes the following statement: "My family welcomes the decision of the IOPC to maintain their direction that W80 should face proceedings for gross misconduct. I note that the IOPC have asked the Commissioner to consider asking another force to hold the hearing to provide reassurance about the independence of the process. This is a request that we strongly support. Unfortunately, such a step appears to be necessary in light of the Commissioner's statements in recent days, particularly his letter of 24 September 2023 to the Home Secretary and his apparent capitulation to firearms officers' demands for impunity. The Commissioner's position seriously calls into question whether, when push comes to shove, he and the MPS as an organisation have the will or the ability, in Jermaine's case and others, to hold his officers to account for misconduct. I have been particularly concerned by misleading statements made by the Commissioner about W80 in his letter to the Home Secretary. The Commissioner states, almost 8 years on, W80 is still waiting to find out if the IOPC are going to maintain their earlier direction that they should face a gross misconduct hearing. What it means for the confidence that Londoners can have in their police service is another question altogether."
Officer W80 Director General of the Independent Office for Police Conduct and others.
For the reasons given in the judgment that we have handed down today, this appeal will be allowed. What I propose to do now is to read out a summary of the judgment for the information of the public and the press. It should be noted, however, that the judgment itself is definitive and that what I read out by way of summary is simply for information. On the 11th of December 2015, armed police officer W80 shot Mr. Jermaine Baker dead in circumstances described in the judgment of the Divisional Court. The Independent Office for Police Conduct investigated Mr. Baker's death and recommended that disciplinary proceedings for gross misconduct in using excessive force should be brought against W80. The IOPC concluded that a misconduct hearing would be likely to find that W80's belief that he was in imminent danger was honestly held. The IOPC thought, however, that the panel at a misconduct hearing could determine that his honest but mistaken belief that his life was threatened was unreasonable. The Commissioner of Police of the metropolis disagreed with the legal premise on which the IOPC had based its conclusion, and she decided not to follow the IOPC's recommendation. The IOPC then directed the Commissioner to bring disciplinary proceedings against W80. W80 brought this case for judicial review of that decision by the Divisional Court. The Divisional Court quashed the IOPC's decision, holding that in applying the objective civil law test, in determining that there was a case to answer, the IOPC applied the wrong test. It should, they said, have applied the criminal law test. The Court of Appeal has decided, after a 3-day hearing, that the question depended on the proper meaning of the applicable statutory conduct standard and the Code of Ethics published by the College of Policing. That conduct standard was that officers should only use force to the extent that it was necessary, proportionate, and reasonable in the circumstances. The Code of Ethics provided that officers had to, quote, account for any use of force, in other words, justify it, based upon their honestly held belief at the time that they used the force, close quote. The IOPC and Ms. Demetriou, representing Mr. Baker's family, contended before the Court of Appeal that the words of the conduct standard and of the Code of Ethics were clear. If officers held an honest but mistaken belief as to the danger faced, a misconduct hearing would only find them to be guilty of misconduct if their mistaken belief was unreasonable in all the circumstances. And the Code merely explained that officers must, after force has been used, account for or justify its use based upon their honestly held belief at the time. W80, the Commissioner, the National Police Chiefs Council, and the Divisional Court all took a different view. They regarded the Code of Ethics as providing a clear pointer to the application of the criminal law test for self-defense. They submitted that an officer would only be guilty of misconduct in the circumstances of this case if his belief that he was in imminent danger was not an honestly held one, or if he'd used more than the minimum amount of force necessary. They argued that once it was determined that the officer held an honest belief that he was in imminent danger, there could be no inquiry in misconduct proceedings as to whether that belief was a reasonable one to have held in all the circumstances. Thus, they argued that once the Director of Public Prosecution had decided, as she had, not to prosecute W80, there was no possibility of misconduct proceedings being successful. The Court of Appeal, therefore, had to decide whether the Divisional Court was right to quash the IOPC's decision. The question was whether or not the IOPC was justified in concluding that on the basis of the applicable conduct standard and the provisions of the Code of Ethics, it was open to a reasonable panel at a misconduct hearing to make a finding of misconduct if W80's honest but mistaken belief that his life was threatened was found to be unreasonable. The IOPC submitted that this conclusion was soundly based in law. W80 submitted that it was not. The decision of the court. That the standards of professional behaviour required of police officers are statutory, and that standard is elaborated upon and explained by the code, but the code cannot alter the standard itself. The question was not whether the standard, as explained by the code, was more consistent with either the civil or the criminal test for self-defense. The meaning of the standard was not to be judged by specific reference to the facts of this case. There were a multitude of situations to which the standard applied, such as where force of any kind was used, for example, in arresting citizens, restraining them, and taking them into custody. It was wrong to say that there could be no misconduct wherever an officer used proportionate force based on an honest belief that he was in danger. If the officer made an honest mistake, the disciplinary panel must still determine whether the use of force was reasonable in all the circumstances. In many cases, an honest mistake is also likely to be found to have been reasonable in all the circumstances. But there will be some cases where it will not. It was not the Court of Appeal's task to speculate on the numerous different situations that might occur in practice. The Code of Ethics itself was deliberately written in plain language and was specifically intended for the use of police officers, staff, contractors, and the public. It would be wrong to introduce a technical meaning which was not apparent on the face of the Code of Ethics. Neither the relevant regulations, the Home Office guidance, nor the Code of Ethics made express reference to the criminal test for self-defense. It would, therefore, be inappropriate to read such a test into a simply drafted and readily comprehensible standard without clear words. The public would reasonably expect the standards of conduct to apply without any gloss. Moreover, W80's submissions would prevent public scrutiny of the serious situation that arose in this case. The investigation by the IOPC had been privately undertaken, whereas a misconduct hearing would be conducted in public. The suggestion that the conclusion was unfair because W80's training had been conducted on the basis that the criminal test for self-defense would apply in misconduct hearings could be made in mitigation if that became necessary. So our conclusions are that the Court of Appeal held that the Divisional Court was wrong to quash the IOPC's decision. The IOPC was justified in concluding that it was open to a reasonable misconduct panel to make a finding of misconduct if W80's honest but mistaken belief that his life was threatened was found to be unreasonable. And that conclusion was soundly based in law on the proper and plain meaning of the relevant regulations and the Code of Ethics. Accordingly, the appeal was allowed, and the IOPC's decision to direct the Commissioner to bring disciplinary proceedings against WAT would stand. That concludes the summary. The parties have submitted an agreed order for the court to make, but they have asked for 7 days in which to consider whether to apply for permission to appeal the Court of Appeal's decision to the Supreme Court. We will grant them 7 days for that purpose, and we will only draw the order when we have heard and determined any application, if it is made, for permission to appeal to the Supreme Court. That concludes today's hearing.
The Met Police was delusional, chaotic and unprofessional when a force marksman shot dead a father of 2 to foil a prison breakout plot. But the unarmed man was lawfully killed, an inquiry has found. Jermaine Baker was fatally shot at close range by police as he sat in the front passenger seat of a stolen Audi A6 near Wood Green Crown Court in North London in December 2015. Officers suspected he was one of 3 men waiting to try and break inmate Izzet Eren, a member of notoriously violent gang, the Tottenham Turks, out of a prison van. Mr. Baker, from Tottenham, was unarmed at the time he was shot by a counter-terrorism specialist firearms officer, CTSFO, known only as W80, who told the inquiry he thought the 28-year-old was reaching for a weapon. An imitation firearm was later found in the rear of the Audi. Inquiry Chairman, His Honour, Clement Goldstone QC, concluded that while Mr. Baker was lawfully killed, there were police failings at almost every stage of the operation, which would serve as a loud wake-up call to the next Metropolitan Police Commissioner following the resignation of Dame Cressida Dick. He said police chiefs were fixated and obsessive with their mission to stop the release of Eren and crack down on the Tottenham Turks, that they couldn't see the flaws in their approach. Mr. Goldstone suggested the operation would have little effect on disrupting the activity of the Tottenham Turks or on achieving sustained public protection. He added, the idea that this operation could succeed in ridding the streets of North London of lethal firearms was delusional. In reality, one firearm was the best the MPS could hope to recover. Bizarre decisions included an insistence not to consult Serco, the firm running the prisoner van, of the operation plans due to fears of corruption within the company, which Mr. Goldstone described as unspecified, undocumented and unsubstantiated. Had the force included them in planning, officers could have controlled Eren's van as well as who else was inside and the route it took from the prison to the court, he added. Reporting on the shooting itself, Mr. Goldstone said, I conclude that when W80 shot Mr. Baker, he held an honest and genuine belief that Mr. Baker was moving in order to reach for the firearm. As such, W80 perceived that Mr. Baker posed a lethal threat. I draw the conclusion, on the balance of probabilities, that the perceived threat from the actions and movement of Mr. Baker was such that W80 honestly believed that it was reasonably necessary for him to shoot at Mr. Baker. Mr. Baker's mother, Margaret Smith, said her son was no angel, but that he should have gone to prison rather than be fatally shot, and called on the inquiry chairman to consider whether her son being black could have been a factor in him being killed, but Mr. Goldstone said he found no evidence to support a finding that race played any part in Mr. Baker's death. He also said that W80's overall credibility as a witness remained largely intact. The inquiry chairman highlighted a number of failures, including that public safety should have been, but was not, the primary objective of the operation, that intelligence that the conspirators had only been able to source an imitation firearm was not passed on to W80 and others, and the delusional idea that the operation would succeed in ridding the streets of North London of lethal firearms. The inquiry heard that Mr. Baker may have been asleep at the time he was shot, and may have misunderstood contradictory instructions, shouted by armed officers who challenged the men in the Audi. A police bug in the car captured a wall of noise with some officers telling the group to raise their hands, while W80 said he had instructed Mr. Baker to put his hands on the dashboard. No live firearm was found in the car, in which Mr. Baker was a front seat passenger, but a replica Uzi was discovered in the back of the car. Officers had intelligence that the group had been unable to obtain a real gun, but this information was not passed on to the firearms team who confronted the men. W80 told the inquiry he was convinced that they would be armed and would fight their way out, rather than surrender when challenged by armed police. The report said, the combined effect of the evidence of Detective Inspector Robert Murray, Detective Chief Inspector Neil Williams, and Detective Superintendent Craig Turner reveals a determination, bordering at times on the obsessive, to achieve a successful outcome to Operation Anchor, and with it, if not the demise of the Tottenham Turks, then certainly their emasculation. Whilst this may have been a laudable objective, it should not have been something that was allowed to go ahead at virtually any cost, and to the exclusion of proper and meaningful risk assessments and safety considerations, as well as compliance with protocols. There can be no doubt that sustained public protection was the prime objective of this operation. The safety of the public was not, and it should have been. The most that the officers could have hoped for on the day was the arrest of some small fry and the seizure of one gun, the inquiry found. The available intelligence supported the likelihood of a failure in achieving sustained public protection, save for the small fry who were to be arrested at the scene. The report said, the idea that this operation could succeed in ridding the streets of North London of lethal firearms was delusional. Realistically, one live firearm was the best the Metropolitan Police Service, MPS, could hope to recover. Unfortunately, those who decided that the operation should run were unable, because of their fixation on their desire to solve the Tottenham Turks problem at a stroke, to appreciate the flaw in their approach. The inquiry found a series of technical failures in the planning and execution of the armed operation. It said that officers had failed to consider any possible outcome other than an armed stop, and had not properly assessed the risk posed by Erin's cousin Oscar Erin, who was behind the escape plot. They also failed to engage with the prison service about Erin's escape risk or tell prison van staff of the planned jailbreak. The chairman found that failures in the planning and execution of the armed operation should act as a loud wake-up call to the next Metropolitan Police Commissioner, who is due to be appointed this summer. He said, "I cannot help but believe and observe that if Mr. Baker had not been fatally shot, none of the shortcomings in planning and execution which this inquiry has exposed would have come to light, and the operation would have been hailed as an outstanding success by and for the Metropolitan Police Service, MPS. If it achieves little else, therefore, this inquiry should serve as a loud wake-up call to a newly appointed commissioner." Mr. Goldstone said in a foreword to the report that previous Met boss Dame Cressida Dick had acknowledged that not everyone has confidence in us to provide a good service when they need us. He said, "Those within the corridors of power in the MPS cannot expect any increase in that level of public confidence without a willingness to accept and act upon justified criticism." In his conclusions, he added, "It is clear that little, if any, thought was given to the tactic of contain and call out. This brings into focus the question of why there was no serious, if indeed any, consideration given to it. Whatever the higher echelons of the MPS may believe, there is, in my view, a widely held opinion within the MPS that, in an urban environment, the option of contain and call out is unlikely to be practical, and can therefore be discounted at an early stage. The way one describes that opinion is less important than its existence." The CTSFOs were deployed to the Audi mission vehicle with a working strategy that increased rather than minimized risk. They did so without even the knowledge of how many individuals were in the Audi mission vehicle, and they had no plans for achieving sight into it and for communication with the subjects. This led to an extraction that was somewhat chaotic and unprofessional. The inquiry found that failures by Detective Chief Inspector Neil Williams, who was Tactical Firearms Commander on the day, did not amount to gross negligence and did not cause Mr. Baker's death. Lawyers for Mr. Baker's family had highlighted failures in handling of intelligence and not using available surveillance tools to reduce the risks of an armed interception. The inquiry found that Mr. Williams did not know where Oscar Aaron was in the early hours of the operation and whether he would be involved in the breakout. The officer also did not think through the consequences of potentially corrupt prison guards altering the route on the day, it found. Mr. Goldstone said it was astonishing that this was not considered. The terms of reference for the inquiry covered the planning of the armed operation, what information was available to those involved, how the operation was led, and what the officers did on the ground, and what happened in the aftermath of the shooting. The CPS decided not to bring criminal charges against W80 in 2017, and the officer is involved in a legal battle over whether he should face misconduct proceedings. The CPS decided not to bring criminal charges against W80 in 2017, and the officer is involved in a legal battle over whether he should face misconduct proceedings. Speaking to reporters in London after digesting the report, Margaret Smith, Mr. Baker's mother, said, "Jermaine was dead before he got into the car. The judge has pointed out numerous really serious failings by the Met. Running the risk that my son's life would be taken was never justified. Jermaine's life was taken for no good reason. As I've always said, Jermaine should have gone to prison like the rest of the men in the car. I cannot agree with the judge's conclusion that Jermaine did not die as a result of these failures. That is a conclusion I cannot understand. After 7 years of waiting, we deserve more. We know Jermaine was unarmed. Jermaine complied with the instruction to put his hands in the air. We know this from the forensic evidence. Jermaine was surrendering. Jermaine could not have done more to save his life." Tia Demetrio, the mother of Mr. Baker's 9-year-old daughter Alexia, said his death continues to have a significant impact on her life. She said, "There will be moments out of the blue, especially if she, Alexia, hears sirens or sees police officers. She's petrified. She doesn't know how to react to these people. There is plenty of time throughout her life when she feels different from other people because she doesn't have her father around, and it's really misfortunate because he really was a brilliant father to her. I'm going to go back and explain to her, no matter what this report says, that her father was unlawfully killed, and I will stand by that for the rest of my life." A Met Police spokesperson said today, "Our thoughts are with the family of Jermaine Baker as the public inquiry into his death publishes its report. We offered every support to the inquiry and submitted detailed evidence which can be found here." The inquiry report criticises how the policing operation was planned and carried out. The inquiry's conclusions, however, were that these failures did not cause Mr. Baker's death. It was reasonable in the circumstances to assume that someone in the vehicle would be armed with a real firearm and that Mr. Baker was lawfully killed. Since Mr. Baker's death, we have made changes to how our firearms command operates in London, including how operations are run and overseen, how we train and support officers involved, and how we keep records. We are always open to improving our capability to tackle the threat of firearms. We will now take time to carefully study the inquiry's recommendations before responding in more detail.